All right, awesome. All right, so today's topic, good afternoon, everyone. Simon Cazares, team leader for KW South Bay. What we're going to be talking about is completing the RPA and certain disclosures regarding buyer or seller entities, okay? How many times have you been across a client that, you know, is an individual like myself, right? Simon Cazares, but they have a corporation, they have a business, right? And now they want to transition and say, you know what, by the way, Simon, I think I want to put it into my corporation. Or if it's a seller that has a trust, right? Or someone passed away and now, you know, they have a successor to that trust. How do you navigate those conversations? And more so, how do you put it on the paperwork, on the contracts? So that's where we're going to dive in deep today in explaining the pros and cons and how all this works for you. When you go for a listing appointment and you get the listing, but it's a trust as an example, right? Family member passed away. Now someone is the successor to that trust. They're the authorized party to enable them to sell the home. But it's not their name. It's not on the profile. It's not on the grant deed, right? It's on the deceased individual. But because they have the authority to do so, then that's where we need the acknowledgement. Okay, so that's where we're going to talk a little bit about and explaining how this all works. So let me, I have a PowerPoint presentation as well. But, you know, holding title to real estate can be a complex decision. Having tax, financial, and the estate planning and the liability also can be a substantial issue and concern. Now, more so in the past, this was common for all of us to buy in our own entity, right? Husband and wife, brother and sisters, sisters and sisters buying. But now that times have changed, now people are utilizing, and it's more common for people to buy and people to hold real estate in either a living trust, a corporation, an LLC, a partnership, and because of the age and populations, you know, people that are in their 70s, maybe in their 80s, even possibly 90s, what we're seeing now is that they have power of attorney. Someone is delegated on behalf of the person that's still alive, but they don't have the capability to do their financial affairs, and more so the sale of real estate. Okay, so how do we navigate those conversations, right? Now, holding a property on a power of attorney or a deceased estate, it can sometimes be confusing, and, you know, understanding the contract itself, you know, and there is what we call the buyer and the seller representative capacity. Have you ever heard of that form? Okay, most have, most haven't. But that representative capacity form allows you to know who the party is authorized on behalf of the estate, on behalf of the corporation, the LLC, in order to then suffice and be able to transfer ownership. Okay, so let me go ahead and screenshot.
Sorry, you pick that up.
Yeah. That. There we go. All right. So the legal authorization and the signer, since entities can only act as individuals, real estate contracts enter into on behalf of the entity must be signed by an individual person who is legally authorized to sign for the entity. The legal authorization signer is acting not as the person, individual capacity, but rather as a representative capacity for the entity, okay? And again, that's going back to corporation and LLC. a trust, even sometimes a probate, the judge or the court appoints someone as the authorized party on behalf of the probate as well. Therefore, the signatures or initial binds the entity, but does not create the legal obligation for the individual, okay? And we'll dive in a little deeper on this. Completing the RPA and the agency disclosure related to the addendums in place. A contract enter on behalf of the entity should identify the entity as the buyer or the seller. So yeah, when you represent either party, what we need is, do you have the authority to do so, right? We're not just going to go on a listing appointment, right? Or on a buyer consultation. If they say, well, yeah, you know what? I'm the owner of this company and I want to buy this property under my corporation, my S Corp, my C Corp, or my LLC. Okay. Well, we still need what? We need proof. Okay. Because even though they want to buy or they need to sell, title is going to need all these documentation. And if you are working with someone that has a corporation and wants to buy on behalf of the corporation, that's perfectly fine. And we are allowed to work with individuals that do have corporations, but we need to know who the person, the officer, is it a CEO? Is it the president? Who is the person that's authorized on behalf of the corporation? So what we need is copies of what? The articles, because the articles is what's going to be able to identify and let us know who is the authorized party to sign on behalf of the corporation, who is the person or the party assigned to be able to sell on behalf of the deceased, right? Parents is a prime example, right? We as children, we encourage our family, or your parents should be proactive, when they get to a certain age, if they have any type of assets, right, to start a living trust. Why? Because if they do not have a living trust, what happens? The state now takes control. Now you have to file for probate, and that can be very costly and very timely as well. So by having a family trust, it protects the umbrella of the deceased, right? Let's say it's a husband and wife. Husband passes away, then most of the assets will revert to the wife, or vice versa. Or let's say it's a new relationship, right? But they have existing children from a previous relationship, right? Maybe children's from their first wife. Now they're in a second relationship, and now they merge two families together. For the sake and the protection of one of the significant parents is, willing and giving something on behalf of you to your children, right? And then now you can separate by percentages that are going to go either equally or a percentage higher or greater to one of your children, okay? So there's many ways in how you can approach this, but if we have the right information, then we understand who, especially as real estate professionals, we don't want to go through the motions, right, of working with the client, and then at the end, we cannot even facilitate this because they are not the authorized party to sign off on it. Make sense? Okay. So the forms that are a part of this agreement is the car contracts identifies the trust by their shortened name, or the trust is acceptable as long as the full name is provided on the signature page as the representative capacity signature disclosure, better known as the RC SD or the RCBD form attached to the contract. The legally authorized signer must also provide the proof of the authority to sign pursuant to paragraph 3N-5 and 28 of the RPA, the purchase agreement, and similar provisions in other car contracts. The trust as an example. If the buyer intends to hold title in the name of a trust, such as the Wayne Family Trust, FBO, for benefit of, or Oprah Children's throughout the city of Gotten Bruce Wayne Trust, the buyer can be named in paragraph I and 32D as in David of the RPA, simply as Bruce Wayne Trustee or Wayne Family Trust. So if you do happen to come across a family that does have a property in a trust, then these are the appropriate ways of doing so. Bruce Wayne Trust, or it can be, whatever the Smith Family Trust, the Smith Trust is perfectly fine, okay? And that can be identified on the very end of the purchase agreement. Estate, as an example, if the property is being sold through a deceased estate, such as the estate of Tony Sharp, AKA Iron Man, filed December 31st, 2019. Okay, and what that means is, when was the trust created? Okay, maybe the trust was created 10 years ago, 15 years ago, or maybe it was created six months ago, and now the deceased is now in the authorized of the successor to allow the individual to sell the property. So on the RPA, the simple is the estate of Tony Stark. Now, here's the big picture and how I see, because I get a lot of people get a little confused when they go into the property profile, folks, the property profile, okay? And on the property profile, it allows you to go and see how it's done, how it's written, how it's indicated, if it's the family trust. And you can always ask the listing agent also, so we can understand the dynamics on this. What is the appropriate name and how I should facilitate this on the offer? Because what's going to happen is that once your offer gets accepted, right, you open escrow. Escrow is going to ask for the documentation, but they're also, if it's incorrect on the RPA, then they're going to ask for a revision of it. They're going to ask you to do an amendment to sign and understand that the name of the trust is not what you put, but the name of the trust is what this is. And that's perfectly fine. It's just a little bit more time and effort needed in order for you to do so. Now, let's talk a little bit about power of attorney as an example. If the property is being sold by a person holding power of attorney for the seller, such as Peter Parker holding a power of attorney from Aunt May, the seller can be identified in 33D of the RPA as Peter Park under POA. So you can put it as, as an example, if I am the authorized on behalf of the individual that is incapable of facilitating the documentation, then I would say it's, Max Ride, POA. Then you would put the POA, or you would put, power of attorney. And that allows Max, as an example, the authorization on behalf of the person that is incapable of signing off on these agreements. Then that's what you would put on the contracts. The legally authorized signer must be identified in the RPA under paragraph 33B3. Once properly identified in the RPA for purpose of the transaction, whenever the legal authorization signer's signature or initials appear, all parties are deemed to understand that the entity, regardless of the type, not the individual, is bound. So regardless is if you are not the actual owner, right? Mr. and Mrs. Smith is the actual owner of the property, but you are part of the power of attorney on behalf of one. Let's just say that your mom, God forbid, had a massive stroke and now she's incapable of signing, right? Or remembering even her own signature, but the son would be part of the power of attorney, or daughter, they would be the authorized party. You're not going to sign and forge your mom's signature as an example, but you're going to put your name as Max Ride, POA. Okay. And that says to the escrow, that says to title that Max Ride, the power of attorney, is authorized on behalf of maybe Mrs. Wright. Does that make sense? Okay.
Do you just need, sorry, do you just need to put it in the RPA, like when you write a listing, or do you actually need like a legal document from like you actually need to get the legal?
Well, it all depends. If we are the ones buying a property, yes, we're going to need documentation because escrow is going to need proof that you have the authority on behalf of the individual to sign off on the paperwork. That includes the purchase agreement and any disclosures.
How about like if you represent the seller and like you said, like the seller is an older person that can't, you know, share that somebody,
Yeah.
do you need something like a paper?
Yeah, so we're definitely going to need something from, well, not the listing agent or the agent itself, but escrow was going to need it, and probably title, because they want to make sure that we can transfer ownership from one owner to the other owner. So they're going to want proof. And if that proof is the POW, or excuse me, POA, then that gives you and grants you the authorization on behalf of the person that's still alive to be able to do the transfer and the sale of the property. Okay, good question. Now, it's very far and few, and I really encourage that any agent that is working with someone that does have a power of attorney is to get the proper documentation. Don't just go listing a property because someone has the power of attorney. And the reason is because usually how a power of attorney works is the person must be incapable, right? Mentally or physically something transpired that the homeowner is not allowed anymore the ability to sign off on something. And you got to be very, very, very careful. Sometimes you need two letters from a physician that, you know, puts this individual incapable of handling her or his or their financial obligations. And they were appointed either a family member or a child on behalf of the parents to sign off on the assets that they have. Question.
I've never dealt with power of attorney, but let's just say if like someone becomes Alzheimer or something, like they get the power of attorney when that happens, or do they usually have the power of attorney ready? Like,
yeah, that's a very good question. So you don't want to do anything until you have everything aligned. So that's when, you know, the individual that's going to be taking care of this or will be the person authorized, they need to be speaking with an attorney. And then the attorney will navigate, well, you're going to need two, you know, physicians to sign off that the individual is incapable of signing on behalf of the grant deed, or even financial stuff, you know, bank accounts, right? Credit cards, you know, even utilities, car payments and all that stuff. It's not just real estate. It can be a severity of many, many avenues when it comes to the obligation and the responsibility. This is just one of many things that can occur. Now, this is probably going to be the biggest, and we have to, as real estate professionals, make sure that we are on cue, that we have everything aligned, because I don't want you to go through the motions. You're in escrow, right? And escrows cannot continue because they're not the authorized person. They're not able to transfer that to the new buyer. And then that causes time, effort, and frustration to us. And ultimately, if you have a buyer too, that means you would have to cancel. Now, you know, stuff like that, you want to make sure you bring it to your broker's attention. And then we have to either navigate it or ask more and more questions, because again, going through the motions of getting a listing signed, and I've seen this firsthand, folks, where an agent goes and gets a listing because they are compelled that this person has a power of attorney. Well, in this instance and scenario that happened, that person did not really have the authority. It was the other sibling that actually had the proof and documentation. And what they showed up was just a mock example of it, and it looked like it was forged. But they wanted to be the ones facilitating the sale. Now, the listing agent wasn't aware, you know, they said, cool, we have a listing. You know, this individual has the authority to sell on behalf of the mom, who is now unable to take care of our obligations. And one of the things they wanted to do was sell the property. But escrow ultimately stopped it because title cannot verify this POA. So that stopped everything. And now we found out that it wasn't this individual, but it was another sibling that had the power of attorney. But we had to cancel with this buyer and restart everything and restructure everything. And unfortunately, this buyer ended up going in a different direction because we just didn't have the right information at the time. And it was frustrating for the listing agent because the listing agent thought, cool, you know what? He is the authorized, he has the POA, he's granted me the permission. But ultimately, what ended up transpiring in that, we didn't even get the listing. The other sibling ended up getting another listing agent involved because we did not have the right person in charge of, facilitating the sale. So again, that can happen, folks. So be very, very, very careful. All right. So the entity and signatures, the trust buyer, corporate buyer, trust seller, individual seller, buyer, Wayne Family Trust for the benefit of Oprah Child through the city of Gotten Bruce Wayne, trust buyer to Wayne Industries. So we're just going through the elements and how this all would look like. Jonathan Kent and Martha Kent, Smallville Family Farm Trust, or for the benefit of Clark Joseph Kent in the Lewis Lane dated January 1st, 2001, Deanna Prince, trustee seller, and Clark Kent as the individual. So here's just some of the examples of what you would be putting on the listing agreement or the purchase agreements as well. Entity and signatures, LLC buyer, partnership buyer, estate seller, power of attorney seller, buyer, Hope Development LLC, buyer to Avengers Enterprises, partnership seller one, estate of Tony Stark, seller two, Peter Park under power of attorney for Aunt May. And I'm going to show you an illustration of where you're going to put this information on the very end of the representative capacity, which is a 2-page form. And this is where it illustrates who is the authorized party to be able to sell or purchase a property. All right, so here's an example of the offer on the RPA, right? The offer, this is offer from Bruce Wayne Trust, Wayne Industry, Inc. So it can be a trust or it can be a corporation. This is where you're gonna put this information. Now, on the very beginning of the RPA, it already illustrates who is the buyer, right? You're not gonna put Simon Cazares if I am transitioning into a corporation or buying it on behalf of my trust. But I've seen examples too, folks, where someone will buy it as their own personal and then transfer it into a corporation or a trust, and that's perfectly fine. Maybe they want to change how they vest title. So what I recommend is if you do have a client that is thinking about possibly taking it out from an individual, putting it into a trust or a corporation on the RPA, so that way it allows escrow to understand that you're going to put, as an example, max rights or has the ability to transfer it to vesting as well. Okay, meaning that, yes, I'm buying it as my individual, but I also have the understanding that if I want to change an escrow during escrow, that I want to put it into an escrow, into a corporation or a trust, then that grants me the opportunity to do so. So you're already putting that the buyer has the authorization or the choice to put it in a vesting entity as well. Something different than your personal name. Does that make sense? Everyone on the same page? And that can be a trust. And there's people that they say, you know what, God forbid something happens, right? We close and, I go on a trip and, the plane falls and I pass away. But because I created that trust and it was transferred, then we should be okay. It would not have to go through probate. Okay. So this is the reason people do what they do, for the protection or the umbrella, or even the corporation. Maybe the corporation has many officers as well. And these officers grant some responsibility. You know, the CEO of the corporation or the manager is the authorized on behalf. Maybe you have the CEO, but the vice president or the president or the manager has the authority on behalf of the corporation, even though, let's say, they're still a CEO, but you grant this individual the opportunity to purchase, okay, or the opportunity to even sell if they have a corporation that it is the entity and the entity is the corporation that owns the property, but you have officers that can sign on behalf. All we just need is proof. That's it. And once we have the proof, then this is the person that's going to be signing the disclosures, any escrow instructions, any back and forth documentations that we need. Any questions regarding that? Okay, does all of that make sense or a little confusing? All right. Here's the entity number 4. Okay, where it says entity seller note. If the paragraph is completed, a representative capacity signature disclosure car form RCSD is not required for the legal authorized signers designated below. And then it goes through the motions. The name of the legal authorization is Dana Prince. It includes Jonathan Kent and Martha Kent from Smallville Family Trust for the benefit of Clark Joseph Kent and Lewis Lane, dated January 1st, 2001. So again, it gives you an illustration. If there is an entity, then the person that is authorized would be putting their name as the individual, and then whoever is part of that trust. And then the signatures, obviously, you still put the name of the trust, but you're going to sign as your name as on behalf of the trust. You're not going to, and I've seen this happen quite often, is if it's the Kent Family Trust, they sign it as Kent Family Trust. That's not the appropriate way to do so, okay? Because that's not a legal entity signature. But the individual like Simon, like, you know, Max as an example, they're the ones, and this is the reason we have the representative capacity, because it illustrates and it puts into perspective exactly who is the legal person on behalf of the trust and the corporation, okay? Again, here's another example offer. This is the offer. So this is on the first page of your purchase agreement. If you are representing a corporation or a partnership, this is how it is, just based on the corporation. You know, most real estate professionals, when they buy investment properties, they use their LLCs, they use their corporation. So you're gonna, if you're gonna submit an offer as a corporation, you want to put it as it's illustrated and licensed in the state of California. So here's an illustration. This is the Hulk Development LLC, or the Avengers Enterprise Partnership. Sometimes when you're doing investments, flipping properties, you'll syndicate with the other partners and you bring the money together, right? And instead of an LLC, it's a partnership. And that partnership is what you're going to put, as long as it's registered, right? And we have some type of DBA or a LLC or corporation, or even if they created a trust, as long as we have the documentation for it, then that's how you're going to draft these agreements. Okay, any questions? Again, here's another illustration as the entities for the buyer. Okay. Estate of Tony Starks, Peter Park under the power of attorney for Aunt May. So again, if you have that POA as an example in the illustration, you want to make sure that you have the proper documentation to support this position, because again, we don't want to go through all that motion, right, and then stop and escrow, right? And because they're not the authorized person, then we have to cancel escrow, and it happens quite often. All right, and that pretty much concludes our class. Any questions regarding, trust, LLCs, corporation? Now let me just show you what that form actually looks like. Okay, and that's part of your ZIF forms. Okay, everyone see that? All right, so this is the representative capacity signature and disclosure for seller representation. When you go on a listing appointment, you either ask those questions up front, or when you're on the listing appointment, you're going to know that the that the property is either on a trust, LLC, or corporation. You better be prepared to have this document on top of your listing agreement. And it's a simple 2-page agreement that is one for buyers and one for seller. What I'm illustrating here is the seller representative capacity form. And here you're going to put, if it's a listing, right, the agreement, the property address, the buyer, and the seller's information. Now it falls into different categories. 1A, 1B, 1C, and 1D as in David. So if the property is in a trust, you're going to check the trust, and then you're going to put in, as I indicated earlier, what is the name of the trust? The John Smith Family Trust. And then this is where you're going to put John Smith Family Trust. Now, where it says date, that's the date that the living trust was created. That's the day that it was officially given to the consumer. That's the day that it was ultimately created. It could be 5 years from now, 2 years from now, or even 6 months, or even last week. That's the date that you're going to put, and it'll have it on the front page of the living trust when the trust was created. If it's an entity, guys, okay, and you're going to check off entity. The seller is a corporation. The seller is a limited liability LLC. The entity is a partnership or any other, which has authorized the officers, as I said earlier, managing members, partners, persons signing below, to act in its behalf and authorizing resolution of any equitable bodies of the entity described above. Is or is attached. Okay, if it is attached, you want to provide the necessary documentation to it. And here is your POA form, the power of attorney. Again, any of these elements that you are in a position to work with, you have the documentation that allows you the opportunity to service a buyer, service a seller. The power of attorney, seller principal has authorized the person signing below, the attorney in fact, and the power of attorney under the POA to act in his or her behalf pursuant to the general power of attorney or a specific power of attorney if there's a specific power of attorney. And again, it goes back to when that creation of the form was done. If the property is under an estate, usually like a probate, is it seller is an estate, conservatorship, guardianship, identified by the superior court, then if that's the case, we need to know who the court is and what the court case number is. And you're still going to utilize this form because they may give you and grant you the opportunity, not this moment, but 30 days from now, 60 days from now, 2 weeks from now, you'll have the opportunity, but you have the documentation in place that gives you the authorization on behalf of the estate. Okay. Then once you have this completed, then is the execution of the principal person that's going to be in charge of any of these different entities that they will sign. So if it's Mr. John Smith, right? So John Smith will be the representative name. And then here you'll put the name of the title. Maybe he is the CEO, excuse me, not CEO. And then here, John Smith is going to sign the seller, right? And then it's going to date it. What we already have is the corporation, right? and this is a corporation, then that's the corporation that we have the authority on behalf, the authorization as one of the officer or as the principal owner to be able to sell or purchase a property. Okay, any questions? All right, so on time of sale, seller and John Smith, the buyer, are parties to the purchase agreement dated, and that's the date that the offer was presented. Then the buyer will sign acknowledging that John Smith is the CEO of the corporation. And then at time of listing agreement, the seller and the brokerage, that's where you're going to put, if you're going to be representing the seller, you're going to put Keller Williams as the authorized party to list the listing agreement. And whenever you listed the property, say today or yesterday, or in the future, you want to put a date here, then that's going to be the date that you put. As an example, today, April 5th. You put the name of the brokerage, right? And then you're going to put yourself as on behalf as the listing agent, as an example. Okay. Any questions on that? No difference then on the buyer too. The buyer's representative capacity is no difference as well. It has the same information, but now it just changes from a seller to a buyer. But the information is pretty similar to the seller's representative capacity. Okay. Any questions? All right. Well, then that concludes our class, guys. Thank you very much. Really appreciate it. Okay. And if you have any questions, you can always email me as well when it comes to this. Again, it's a very simple and very self-explanatory, as long as you know that if it's a trust, an estate, corporation, or an LLC, you're going to need this additional form. Now, the cool thing is you don't have to think about it. If you are representing any of these entities, you just click on the entity and it'll populate this form for you. Very simple. So it'll be part of your checklist of offers as well. Okay. Cool, Tim. All right. I appreciate you all. Thank you very, very much.
Thank you.
Thank you.